Good evening. This is Rahul Reddy. We are live here from Houston, Texas, every week on Tuesday from 5 p.m. to 6 p.m. Central Time. We do bring in immigration updates. Emily, what do we have today to discuss?
Today we want to talk about the common thing we've talked before about opening a business if you're on H-1B or L, and how exactly can you do that? We always say you can invest in the business, but you can't work for the business. What exactly do we mean by that? We'll get into more detail. Also, we're always seeing this problem with H-1B holders reaching their 6-year limit and the PERM is still pending. PERMs are now taking 10 months. They're processing cases filed in September 2022, and that doesn't even count the prevailing wage processing time. So what are your options in that situation? And then we see a lot of times people are coming in on a visitor visa, a B2 visa. What are the potential risks of filing an extension of that B2? Normally, the maximum amount of time you can come into the U.S. is for 6 months. What if you want to stay longer and file that I-539 application? What should you be aware of during that process? And lastly, we're seeing issues, as we normally do, with F1 students and filing the OPT application or the STEM extension application. There are very specific timeframes, very specific documents needed. And if you miss something, you're going to end up with a denial. USCIS doesn't really send RFEs. They just reject the whole thing. And then you lose out on possibly 3 years of employment authorization. So what are the common errors we're seeing with people that are filing for the OPT and STEM extension?
Emily, when it comes to the H-1Bs and L-1s, especially right now, we know that it's going to take a long time for especially the Indian people to get the green card, though. And people have money. I mean, you know, there are both people working. They're making an income of $200,000 family plus, $200,000 plus. And they have savings. And, you know, they are in this country. They want to invest the money into the country. And then, of course, we have been always saying that you can invest, but you cannot work. Definitely, there are some easy things. For example, if they want to invest in stock market, they can do it absolutely no problem. If they never a problem and they want to trade in the stock market, they can. They just have to pay taxes on any income they get and profit they get it. We already know that. But when it comes to some of the investments, like opening a consulting company and being a director of the company or opening as a CEO of the company, we said, no, you can't do that because you don't have the H-1B there. But there are some gray areas. For example, can I invest in the restaurant? Emily, this is also a couple of questions that I want to ask you, because we told people that to work, it's not allowed, to invest, it's allowed. But sometimes there is some borderline, especially. Can I invest in buying an additional home and leasing it out? Do you see any problem in it?
I don't see any problem with that. I think where we get into problems if it's more of an Airbnb type of situation where you're doing multiple rentals and spending a lot of time kind of creating a business out of these short-term rentals compared to renting out a room in your home for a year or renting out an entire house for a year. That's where kind of the borderline is. But I don't see a problem with purchasing a house and then renting it.
What about my friend is opening a restaurant and I want to invest the money in the restaurant? Can I invest the money in a restaurant? Is that a problem?
I don't see a problem with that, as long as you're not going to the restaurant, hanging out in the kitchen, hanging out by the host stand or anything like that. You can put the money in, you can take the profits and do nothing else with that restaurant.
And also, if you are the director of the company, secretary of the company, we recommend you do not sign any of those things. If you're signing the checks, most probably you are managing the restaurant, which is not allowed. But as far as just purely just investing in the company is definitely fine. What if it's a consulting company, Emily, and that employs people? Can I invest now? Of course, you told that being a CEO of the company or HR of the company is not allowed. But what if I just invest in the company, though, and I don't participate at all? Is it allowed?
Yes, that is still allowed. I think where people get into trouble is when they do more than just investing. They're signing paperwork, they're recruiting for employees, they're signing contracts, anything beyond just literally take my money and then give me the profit, anything beyond that is going to be considered unauthorized, and it gets people into a lot of trouble.
This is the area, guys, where we see a lot of issues. People just think that nobody's watching me, and they do a lot of activities, and they get into trouble with their partners. Sometimes they get into trouble with the employees, and the complaint goes, and then we're in trouble. People think that, no, I'm just doing it. Nobody's going to complain against me. No, don't do it right now. Everything is in internet. Everybody knows everything in the internet. Every communication is through electronic media right now, and you're not going to meet every employee physically and speak with them. So no, everything will be on the phone, everything will be on the email, everything will be on the WhatsApp, everything is recorded. So we recommend you stay away from any of the activity that is involving in the recruitment, management of the company, or running the company. That is not allowed. But as far as just owning a partnership in a consulting company is definitely fine. Anything else, Emily?
No. So how about this H-1B 6-year limit? Say I'm like in my 4th year of H-1B and my company still hasn't started the process. Should I wait around for my company to start the PERM, or should I look elsewhere? Do I need to transfer? What options do I have?
Emily, this previously used to be 1 year that we used to tell people to file. Right now, it's 2 years. And probably I would say when you are in the 2nd year or 3rd year, that is when you should strike a bell. Things are going wrong with you. You haven't started the green card application. 2 years is the time, as you said, it's taking for the labor certification. You don't have any company filing for the labor and I-140. That should ring a bell to you. There's something absolutely wrong. You need to take action. If you have the H4 EAD option, though, I would recommend that you move on to the H4 EAD, because people think that on H4 EAD, you can't file the labor and come back to H1B again. No, you can. On the H4 EAD, the company can file the I-140 application. You're saving some time for you to later on regain at a later time. You know that the 6-year limit is there. Unless you have the labor pending for more than 1 year or the I-140 approved, you are out. You can't extend the H-1B beyond the 6 years. So save some time on the H-1B as much as possible. Try to move on to the H-4 EAD if you have the possibility. The other thing is that if you can find some companies that can hire you, that can sponsor you for the labor and I-140, even though if you're not working for the company, absolutely you can do that. And you can shop for it and see if you can find some companies that can file the labor and I-140 though. Now, it may be better for these people, Emily, if they are not getting the employment PERM application sponsored by these big companies, they should move to the small companies, Emily. Why? Because if some of the big companies, Emily, what they do is that they don't, if they are in between the process, let's say they file the labor certification and this guy's 6 year is expiring, that's it. They're not going to file I-140. They're not going to move forward with the application. This guy is doomed. What if this guy had to move to India and then he has to come back? Will this big company will be able to file the labor? And even though while you're outside the country, can they file the I-140? Even though you're not working for the company? Maybe, may not. You need to inquire about those things. It probably may be worth for you to move to a small consulting company that are more flexible in their rules, where they would be even filing for your green card much faster. They would even file your green card even if you are outside the country. Even if you're not working for the company, they can continue with the labor and I-140. You may have to consider this very seriously. There are some companies that we know, I mean, they are hiring all the time, consulting companies, and they will welcome you, and they have their PERM and advertisements and everything ready, and they may want to hire you, and they will hire you, and they are a little bit more flexible, that even if your 6 year is expired, you go to India, they can still extend the labor and I-140 approval and then bring you back out from India to here. They can continue employment while you are in India if your end client permits, so they can do that too. They can even, when you move, there are options where when you are maxing out on the 6 years of the H-1B, you can move on to the B2 application, B2. And while the B2 is there, the companies can continue processing the labor and I-140 application. So check with your company though, because right about the 2 years mark, you need to check with the company. Are the companies willing to be flexible if you don't get the I-140 approval within the 6 year period? Will they continue processing your papers, or will they not continue processing the papers of the labor and I-140? Any other suggestions, Emily, that you?
Yeah, I mean, some of the other things that you can do if your labor is already filed and you're just hoping to get the I-140 approved in time to be able to file that next H-1B extension, you can look into spending some time outside the U.S. You can basically recapture any days that you've spent outside the U.S. since you started your H-1B time. And so if needed, you could go to your home country, work remotely from there, and come back in to recapture that time if it buys you enough time to either get the I-140 approved or have the labor pending for 365 days. You can also consider, if you just need a little bit of time, possibly a quick trip to Canada or Mexico if you don't have a visa stamp, because you can utilize automatic visa revalidation to travel for up to 30 days and come back into the US and then file the H-1B extension for those 30 days. And then hopefully by that point, your labor is approved, you can get the I-140 approved and then file your typical 3-year extension. So that's another option to consider. But the most important thing is to think about these things early. We get a lot of people that schedule consultations with us when their H-1B is expiring a month from now and their labor is still pending and they're wondering what they can do. Your options are much more limited when your 6-year limit is 1 month away compared to it being 2 years away. If it's 2 years away, you can take some strategic vacations over the next 2 years to be able to recapture. If you only have 1 month left, that makes it very difficult, because then if you try to recapture, how many days can you actually do? And you're going to keep filing these petitions, that gets expensive. The company may not want to do that. So most important, think ahead, start thinking about it, as Raul said, year 2, year 3. Don't wait until the end of year 4 to start thinking about that.
With moving to the different topic, Emily, a lot of people who come visiting, the parents especially, come in. And they get normally a 10-year multiple entry visa, and when they come here, they get an I-94 valid for 6 months. That means that they can stay with their children for a 6 months period of time. Is it, a lot of people apply B2 extension nowadays? It's online, so they can file a B2 extension. Is it advisable? What are the potential risks involved in it?
Yeah, I think one of the biggest problems is the processing time. So you might file that application and ask for an additional 6-month stay. And by the time the second 6 months is up, the application is still pending. You don't have an approval yet. And if you leave the US at that point, there's a chance that the consulate in the future could say, hey, your 10-year multiple entry visa that you had before is no longer valid because you overstayed the last time you were here. Now, in our mind, that's not an overstay because you timely filed an extension. But in the consulate's mind, if that extension never got approved, they could view that as an overstay. So that's one of the major risks, is just the processing time may make it impossible for you to get an approval notice before you have to leave, and that can result in your visa being invalidated.
And other risks that are involved is that sometimes because of the technicalities or something like that, the B2 gets denied. Then what happens is that the passport visa is automatically canceled. In other words, if your father has 10-year multiple entry visa, they come here, they extend it, the visa gets denied, and after that they leave the country. Even though their passport visa may be valid for the next 8 years, on the document though, it is technically not valid. They cannot use that to come back into the United States. They have to apply for a fresh B2 visa, and the consulate is not happy when your parents have extended the visa status for more than 6 months in the United States. They may deny the B2 also. And also for those people where the B2 passport visa is expiring and they have done some extensions of the B2 though, especially they stayed more than 6 months and they filed the B2 extension, they got the B2 extension approved. When they go for the stamping though, there is a good chance that the stamping may not be approved because they have used the B2 extension. Now, of course, in the time of COVID and other things, that's fine, that's understandable. But just because you have a child that is born and then your parents stayed for more than 6 months, the US consulate is not going to look as a favorable thing though. So be careful. There are a lot of potential downfalls in filing an extension. Sometimes it may be worth for the parents to just go outside the country, travel, and stay there for a while and come back rather than actually staying over for a long period of time. So definitely do consider these things when you're filing. Filing an extension is easy, but getting away with that is a big task.
All right, next up is filing the OPT or STEM OPT extension. One of the most, with USCIS, they're very particular. There are very specific deadlines. You can't file the I-765 too early. You can't file it too late. One of the big problems we see is people not getting the proper I-20 from their school that authorizes the OPT. They submit the I-20 that they already have, but you actually have to get permission from your DSO first, have them issue you a new I-20 that's specifically for the set period of OPT for 1 year or for the 2 year of STEM OPT. And then once you have that I-20, you have to realize that there's a deadline that you have to file the I-765 within the validity period of the I-20. It's only valid for 30 days from the date that it's signed by the DSO. That's another thing. Sometimes the I-20 gets issued a certain date and then signed on a different date. So you have to make sure that you're filing within 30 days of the correct date. We've seen cases where people filed 2 days late because it was within 30 days of a different time period they were looking at. So those are a lot of the problems that we see. Another major problem is filing the I-765 improperly. So easy to just miss a box or have a problem with your filing fee check. And rather than sending a request for evidence and giving you the chance to correct the form, they just reject the whole thing. The problem is by the time you get that rejection, your filing window may be over. And you don't have a chance then to refile it. If you try to refile it, they don't honor your original filing date. They're going to go by the new date. And so if that's no longer within your filing window, they're going to deny. They'll take your money when you do properly file it, and then 4 months later, you'll get a denial. So you have to be very careful with those. Make sure you know exactly what the time is. Check and recheck every single item on the form. Make sure the signatures are there. Double check that your filing fees are correct. To avoid those problems, because there's just no way to fix them, unfortunately.
Anything else, Emily, before we move to questions?
I think we can start with some questions.
Nepal, my prior to date is March 2023. Based on EB2, rest of the world, will be able to file for adjustment of status based on either final action date or filing date charge coming in October. Well, I'm actually in Kathmandu right now. Yes, I'm in your country right now. Yes, in October, most probably though, it will be the filing charge. Now, it's not guaranteed though, but most probably in October of 2023, it will be based on the filing dates. Since you are from rest of the world, most hopefully so it will be current at that time.
All right, let's see here. There was a question about from Casey. I need to update my DS-160 with the most recent info. How can I do that? So we actually have an article about that on rnlawgroup.com. If you just Google RN Law Group DS-160 correction, you'll find that. But there's a way to go into that CEAC system, the CEAC system for NIV applicants, the DS-160, and retrieve an application. And then you can edit that. There's other options as well that will allow you to upload a previously saved application if you happen to save a version of the application, the DS-160, at the time you submitted it. So check out that article. It gives you some step-by-steps there. Worst case scenario, you can always fill out another DS-160. It'll have a new barcode on it, and you can bring that so that the consulate can get all of the updated information.
Talk to San says, is it illegal to invest in cannabis stocks for the H-1B holders? And the NASDAQ. There are a lot of problems with investing in cannabis. We consider marijuana or cannabis as illegal according to the federal law. It may be legal in the state law, but it's not legal according to the federal law. So, for example, in California and in Colorado, I think so. I may be not right, don't take it. But they say that it's legal to smoke marijuana. It's illegal to buy marijuana. In fact, I went to Portland once. My goodness, there are so many stores of the marijuana, Emily, I can't believe. So people are able to buy it. It's open stores. I mean, light it up, very good. But guys, when it comes to the immigration law, though, which is a federal law, it is illegal. It is still not legal according to the federal law. So whenever you enter into that store, they scan your ID, and that will go to the federal authorities, though. Don't enter into the store, don't buy cannabis. Now, when it comes to the NASDAQ cannabis, though, we still recommend to stay away based on our limited knowledge that we have. Because have we seen anybody getting into trouble investing into NASDAQ in cannabis? Not yet. But what if tomorrow the USCIS will start implementing that? Have we seen people who have bought marijuana, used marijuana when they are in the states where it's completely legal, getting into trouble with the immigration? Yes, there are many instances. Very many instances are there. When it comes to NASDAQ investing, we haven't seen it, but why we should like to have our clients face a future problem. So we advise in general to stay away from those things. But when it comes to investment, we haven't seen the trouble, but we don't know. We recommend still not stay away from those things.
Ragini says, does the EB2 NIW follow the same priority date as EB2 India in the visa bulletin? What are the advantages of NIW over regular EB2? It does follow the exact same date, so it does not give you any advantage in terms of how long it will take for you to receive your green card. So NIW is National Interest Waiver. All that does is let you skip the labor certification, and you don't need a job offer, and you can still apply for an EB2 I-140. That's what the NIW does. If it's in the national interest, they'll let you skip labor certification and you don't need a job offer. You can file the I-140 on your own, but it's still the regular old EB2. So the main advantage is you don't need a job offer. So if you don't have a company that's willing to sponsor your green card, yet you meet the requirements of the NIW, you can self-sponsor your green card. That's the biggest benefit of it. And then the next benefit is you don't have to go through the labor certification process, which takes almost 2 years these days. So you save time there.
Ravi Nagala has, I'm on GC. How long can I stay outside USA? Definitely within 6 months, you should not have any problem. If it's more than 6 months, you should consult a lawyer. What are the regulations that are there is that if it's more than 6 months, the CBP officials, when you're entering into the country, they may, they have an option of refusing entry into the United States. If you stay outside the country for more than 6 months, it will affect your green card application. And when there are ways where you can stay for up to 2 years outside the country, but you have to get a permit called a re-entry permit. But that re-entry permit also has some problems because it will affect your citizenship application, the time when you can file the citizenship application. What we tell people is that if ever you have any plans of traveling for more than 6 months outside United States, you should consult a lawyer before you embark into the journey of staying outside the country. There are ways where you can save your citizenship. There are ways you can save the green card instead of just giving it up, though. We normally recommend that instead of staying outside for more than 6 months at a single time, you may want to make a trip back to United States to save your time, to save your citizenship, though. But definitely get an advice from an immigration lawyer if you're planning for more than 6 months.
Uthu says, my daughter's H4 is valid till 2025, but I got laid off on the H1B. My spouse is on H4 EAD and is applying for her own H1B. And he wants to know, do we need to also apply for the H4 extension for the daughter as well? Yes, because although she's in H4 status, it's tied to her H1B. So when you lose your job, she loses her status. So she needs to file another H4 that's tied to your wife's new H1B in order for her to continue in H4 status.
Sharon Chintapalli has this question. His H-1B max out is November 28, 2023. His employer filed the labor certification, and it may not get approved. What are his options with regards to what are his options with regards to uh, the extending the H-1B and recapturing other things? One thing, since it's November of 28, 2023, you can spend some time outside the country. That's one thing that you can. I want you to go through the first 7 or 8 minutes of the video to consider the rest of the options to see if they are willing to be okay to continue with the green card process when you're not working for the company, or will they be okay if you can continue working for them in India and then continue processing of the labor and I-140, especially at this stage where you are at right now, November 2023, and your labor and I-140 is not approved. I would strongly recommend to consult a lawyer to get a strategic advice what not to do. There is also a PERM labor, the 6 years ending, PERM not approved. There's a video that we made. You can watch that video. It's about 15 minutes video. You'll get a lot of tips from it, but I strongly recommend to consult a lawyer if you need to.
Yahoo Me says, does the I-765 premium processing that's new apply to the GCEAD as well? No, it does not. So that, as of now, is only for the I-765 for OPT and STEM OPT extensions for F1 students. Does not apply to H4 EADs, does not apply to GC EADs. But if you are waiting for your initial GCEAD, the C9 category, based on filing a 485 application, litigation is still an option for you if you are facing a delay in getting your EAD based on that. We are still filing those cases and still seeing improved processing times when we do. So you can always reach out to Stephen Brown in our office for more information on that if your EAD is being delayed based on the pending 485.
Question with regards to Soyam is asking, some organizations are working with the USCIS to let all H-1B applications with approved I-140s to file the 485 irrespective of the priority date. Do you have any information on this one? No, we don't. First of all, I don't think so USCIS has authority to take the 485 application when the priority date is not current. That is what our belief is. What we recommend USCIS is to change the strategy, how they are accepting the applications, is that they can, the administration, they can actually allow the people to file for the EAD and advance parole, and have the people whose I-140 approved give the EAD so that they are independent. When it comes to the I-485, definitely it has to go through the Congress, but to give an EAD and advance parole, they don't need to. In fact, I have written an article just 2 weeks ago on rnlawgroup.com. If you have not subscribed to the RN Law Group newsletter, you should. Now, what I recommended in this article, the administration, was that, look, you are giving EADs to the people of the family-based immigration green who have been waiting for a long period of time. For example, if I'm a U.S. citizen, my sister, let's say, is in India, or my sister is in Colombia, I'm sorry. Let's take not India, let's say my sister is in Colombia, and I filed the green card application. The waiting period is 17 years. Now, the Biden administration is recommending to get these people EAD in advance. They can come into on a parole and they can stay in United States, even though their priority date is not current, and they get an EAD for these people. Certain South American countries were already been given permission. Certain South American countries are under the consideration where they will get an advance parole. They will get a parole to come into the United States. Now, in the same fashion, what they have done for the family immigration, I've recommended the administration to actually give an employment authorization to the people whose I-140 is approved. Please go to rnlawgroup.com. I have drafted a letter where you can send a letter to the congressman and to the administration to consider granting an EAD and advance parole for the people whose I-140 is already approved. Just like the way they did it with the family immigration, they should do it with the business immigration. The reason why they're not doing it for you guys is they are thinking you guys are making tons of money. You don't need any help. jumping the walls and coming into United States. That's exactly the definition, Emily, what they've given when they have given the parole for these people, is that to control the illegal immigration. They are giving them the advance parole. They're giving the parole, and they're giving the employment authorization. Our guys who are actually abiding by the rules and paying the taxes are not getting the benefit, but the other people are getting the benefit. No, so the main reason is that the Indian guys, they don't write letters to the Congress. They don't make much noise at all. And even though we have provided all this information, nobody writes the letters to the administration. So we recommend that you write the letters to the administration. Now, Sayam, I also heard a rumor that the administration is considering to utilize the unused green cards up to 250,000 green cards, though. But at this point of time, it's just a rumor. We don't have any concrete evidence on that one. Emily, do you know anything about that the administration is considering 250,000 green cards unused?
No, I haven't heard anything on that. And I would be a bit skeptical because I feel like that's not something that the administration can do without Congress. I mean, we've had laws in the past passed by Congress that allowed recapture of unused green cards to be used. The law right now specifically states that if an employment-based green card goes unused in the fiscal year, it disappears. That's what the law says. I don't know how the Biden administration could, without going through Congress, say otherwise, because whatever the Biden administration does, it has to be consistent with what Congress said previously. I think we're more likely to get help from the Biden administration by focusing on the family members, not counting the dependents, and the EAD AP for those that have an approved I-140. Those are things that the Biden administration can do. If we get into other areas where the Biden administration is doing things that are not exactly consistent with Congress, that's where it's opening up for litigation from the anti-immigration group saying, hey, the president can't do that, only Congress can. Happened exactly today. The Biden administration tried to change the asylum process and a court struck it down. And he was actually trying to make it harder and the court struck that down. So whatever they do, it has to be in line with what the statute and the laws already say. Anything beyond that are things that Congress has to do, and Congress is clearly not doing anything. So we have to focus on areas where the Biden administration has the best chance of not only taking action, but making that action stick and not getting it shot down by the courts.
Question that is coming from the YouTube is from Ganga on H-1B. Can I do a business which gives commissions on 1099 for tax filings? No. The answer is no. You can't. Question from Prashant. How soon can we move to a new employer after the I-140 is approved? Now, in the best interest of you, though, the I-140 should not be withdrawn within 180 days after it's been approved. Because if they do, then you cannot use that H-1B to extend beyond 6 years of H-1B. You can't use that to get the H-4 EAD. So for you, or if you're considering moving out of the company, the best time would be that wait until the 180 days is over, then you move. Now, the question some of the people ask, oh, I moved before 6 months, but my company did not withdraw. If the company does not withdraw, though, within 180 days, even though you moved out of the company, you're fine. You're absolutely fine. You can use that.
AJ says, can I apply for an H-4 EAD for my spouse along with my H-1B in premium, even though I already filed for an initial H-4 EAD 2 months ago and it's still in process? Yes, I don't see any problem with that. You can file more than once, and I would recommend filing it with the H-1B because you're filing it in premium. They are approving the H-1, H-4, and H-4 EAD all together with that premium processing service versus the very long processing times when you file a standalone H-4 EAD.
Got a very good question. What happens to the H-1B after the H-4 EAD is approved? Very good question from Prashant. It comes very frequently, though. If you move to H-4 EAD, First thing, we already told you that you still can get a labor and I-140 approval. Absolutely, you can. Can you move back to H-1B? Absolutely, you can. If you already have the validity of the H-1B, that means that, let's say, for example, your H-1B is expiring in 2025, and you got the H-4 EAD, and then, let's say, for example, your I-140 is approved, you want to move back to the H-1B, there are two ways you can do it. One, the company can apply for a change of status from H-4 EAD to H-1B. That's one thing. Second thing, if you're continuing working for the same company, you still have the H-1B validity period, though. There is something called, we got it as a margarita switch. You go to Mexico, you have a margarita, you come back. When you come back, you show the H-1B with the I-94 approval to the CBP official saying that you are going to be working with company A, and you're already working with company A, and you're wanted to come into United States on H-1B, and they will grant you an I-94 for the H-1B. So you either can do the margarita switch or you can do the change of status. Though. Now, do you need to be going through the lottery system if you file for the change of status? If you already have the I-140 approval? Absolutely not. You don't need to go to the lottery. You can always come back to H-1B at any point of time, not a problem at all.
Sappy says, I'm on L-1 in the U.S. and I have the advanced parole based on my EB-1C 485 that's pending. If I visit India and come back to the U.S., what will be my status? And at the port of entry, what do I need to mention to ensure my 485 is safe? So it depends on if you have the L-1 visa stamp or not. You can choose, if you have the L-1 stamp, you can choose to come back on your L-1. And it has no impact on your pending 485, and you'll be in L1 status. If you choose to come back on the AP and your L1 approval notice, your I-797 is still valid, has not expired yet, you can still be in L1 status even though you came back on AP. Either way, your 485 is fine. Whether you travel on the L1 visa or you travel on the AP, your 485 is safe. The same goes if you're on L2, H1B, or H4. Those are the only categories that this works for. Other categories, it's not the same. You have to have an advanced parole in order to leave the U.S. And so that your 485 is not abandoned. Now, what do you need to do at the port of entry regarding your 485? Nothing. You are just going to confuse them. So if you're coming back on L1, you show your L1 visa stamp and your I-797 approval notice or your stamped I-129S. That's it. If you're coming back on advanced parole, you might want to carry your I-485 receipt notice along with it, but that's about all you need to do.
Emily, I want to discuss with you with regards to the 2024 fiscal year H-1B lottery. It hasn't come out yet, and the reason I'm thinking about is that USCIS has taken a little bit longer time to input the cases. So normally when we file the applications, we have until June 30th to file the application. It took a longer time for them. We are in July 24th right now, yet we don't see a second lottery there, which we, along with almost most of the other immigration lawyers, also predicted there will be a second lottery. Why do you think so? I think so. It's because they took a long period of time to input the data, though. They may be coming up with the second lottery pretty soon. Am I wrong, or could it be that they already met the requirement, though?
Yeah, I mean, just based on what we expect, the number of people that hopefully didn't file because they did all of these duplicates, I still expect there to be a second lottery. I think it's partly that they're going through the investigative process, looking at all of these duplicate registrations, trying to figure out how to link all of these companies together. I mean, they go through and look at who are the directors of the company, who's the registered agent for the company, I don't even know. There's just such a long list of things that they look at and are able to tie multiple companies together, even if they're not owned by the same people. They can easily see that they colluded with each other. And so I think they're doing that, referring people to law enforcement, and maybe that's some of the delay. Maybe they're looking at how many did file that they might expect to revoke, so they can figure out, because those that get revoked should be going back into the pool to allow more to be selected.
Recently, some of the cases that I got, Emily, was that, as you pointed out, the USCIS went into very length who are the directors of the company, who are the registered agents of the company, what are the addresses of the registered agents of the company. There are other revocations that I've seen, Emily, and the employees are puzzled. Hey, there is no relationship between company A, company B, and company C. I contacted all these three separate companies. I got the H-1B from company B, and they revoked the company B's H-1B. Why? And they're under the misconception that the company A, company B, and company C has to be related company. No. If this particular example was that the end client was Coca-Cola Company, he was working with company A with Coca-Cola Company. And company B filed an H-1B with no end client at all. Company C filed the H-1B. Company B's H-1B got selected. This guy moved Coca-Cola Company to company B, Emily. So that's a good indication that there was no job existing for company B. Because remember, you were not working for company B to Coca-Cola in February of 2022 or before filing the lottery system. You joined that company after the lottery has been selected, which is a very good point for them to catch that it's a fraudulent H-1B. The companies don't have to be related. If the job is the same, it still is considered as a duplicate filings and you will be revoked. And yes, I think so. They're taking a lot more time. But do you think so? There still will be a lottery, second lottery, Emily?
I do think there will be.
Okay.
Let's see. Kieran is on H-1B, has the 485 pending with a May 2014 priority date. He's married and his wife is here on the H-4, and he wants to know if he can add her to the 485 even though his priority date is not current. No. So if you have what we call an after acquired spouse, or for some reason your spouse wasn't in the U.S. at the time you filed your 485 or didn't file with you for whatever reason, and then the date retrogressed, you have to wait until the date becomes current again, and then you need to immediately file the 485, because if your 485 gets approved and you still haven't filed, she's going to lose her H-4 status because you're not on H-1B anymore. That means you're looking at doing a follow to join process where she has to exit and wait at the consulate in order to receive her green card. So it's very important that as soon as your date becomes current, you get your wife's case filed so that it can be filed before your 485 gets approved.
Abhijit Sen has this question from Facebook. He has his green card approved. His family has not been approved. What should he do right now? Can he file F2A, I-130, I-130 and 485, even though they're already in adjustment of status? The answer is yes. They should file an I-130 and 485. You should file an I-130 and 485 application. Because if your priority date is not current anymore, your family's green card will not be approved. So it's not a good idea. It's not a good idea for you to wait until the priority date becomes current. You can always, if your priority date becomes current, you can always use the employment-based and get the green card approved in that basis. But always, it's always good to have both the applications. Whichever gets F2A becomes current, you get F2A. If the employment-based becomes current, you can get in the employment-based.
Arsh says, would people on STEM OPT grace period be able to obtain the cap gap extension and continue working until October 1st if their H-1B gets picked up in the second lottery, assuming there is a second lottery? So assuming what you mean by the STEM OPT grace period is the 60 days following your STEM OPT expiration that you have to stay in the U.S., you can't, if you are selected and your employer files the H-1B change of status before your 60-day grace period ends, your F1 status is automatically extended to September 30th, and you can remain in the U.S. However, you cannot work during that time because your work authorization already ended and you can't work during your 60-day grace period.
Raypurti Ramesh Kumar from Facebook has this question. Is USCIS considering clearing the backlog from the past 10 years and clearing the backlog and giving the green card? Do they have any plans of issuing the green cards for those people who have been present in the country for more than 10 years? the first question is different than the second question. First question, are they trying to clear the backlogs? Yes, they're trying to clear the backlogs. Whether they're successful or not is a different issue. But they will only clear the cases where the priority date is current. I'm sorry, when the priority date is current. With regards to the people who are being present here from the past 10 years, the USCIS doesn't have an authority to just give the green cards to the people who are present here from the past 10 years. It has to come from the Congress. We in the Eastern countries, we call it as a parliament. Here in the United States, we call it as Congress. So it has to come from the parliament or Congress, whichever you call it as. It cannot be administratively done where granting green cards for all the people who are being present in the 10 years cannot be done.
Rakesh says, in EB2, we filed the 485 for both me and my wife and got the EAD. Rakesh is the primary applicant. His wife is thinking to work and wants to know, should she use the H4 EAD or should she use the 485 EAD, which is better? So between the H4 EAD and the 485 EAD, they both give the same type of work authorization, meaning she can work for any employer doing any kind of legal job. She is not restricted in the type of things she can do. She can start a business. She can do pretty much anything with both of those. So the other thing with someone who's on H4 and is the derivative applicant on the 485, not the primary, it's much easier for the derivative applicant to regain H4 status if necessary. If the H4 applicant decided to use the 485 EAD and for some reason wants to get back to H4, they can typically do that just by traveling, assuming that they have either a valid I-797 approval notice or they have the visa stamp. So it's not, if they decide to use the 485 EAD, it's not a final decision. You can come back from it and get back on H4 relatively easy compared to an H-1B holder, for example. Other things to think about is the difficulty of getting the H4 EAD renewal timely. Although there is an automatic extension of the H4 EAD, it only works if your H4 has already been extended. And so if there's a delay in getting the H4, there's going to be a delay in getting the H4 EAD, and you cannot work during that gap. Now, having the premium processing option and filing the H1, H4, and H4 EADs all together helps with that compared to what we were dealing with in 2019 and 2020. But there's still a chance of having a gap when you have the H4 EAD compared to the 485 EAD, where as long as you timely file that renewal, she gets 180 days to continue working after that EAD expires. Right now it's 540 days. That's going to go back to 180 days in October of this year, if I recall correctly. So those are the kinds of things to think about when you're trying to decide. But if she chooses the 485 EAD, she usually has a way to get back to H4 if needed.
Prashant says he has an I-140 approval. He wants to move his wife to H4 EAD. And can she do the business and can she list himself as an investor? Absolutely. You can list yourself as an investor, but the business must be conducted by your wife, not you. So that becomes a little bit gray area when you try to cross the lines, though. But your wife with H4 EAD, can she do business? Absolutely not a problem. Vishwanath Madhukar asked this question. Can the green card holders file for green card for the siblings? Or is it only US citizens who can file the siblings? No, green card holders cannot file for the siblings green card. It should be only the US citizens who will be eligible to file for the siblings. And the waiting period is approximately around 15 to 18 years for the people who are filing for the US citizens. Afreen Sheikh has this question. I'm sorry, the name, I put the wrong name. What would be the ideal time when the 485 interview has been called? What would be the ideal time to get a mock interview by a lawyer as soon as possible? The reason is that when you do the mock interview, though, if there is any faults, there may be some coverages that you can do. Maybe get an experience letter, or maybe get a letter from, get some particular document. Maybe the birth certificate is not proper. You can get the proper birth certificate. So those things can be corrected very easily if the mock interview is done by a lawyer early rather than 1 day or 2 days before the interview because it's very hard to cover the things.
David says he has an L-1B that's valid till November 2024 from Pakistan. His PERM was filed in June of this year, so just last month. And he wants to know if he could possibly skip the next L-1B renewal because he can file the 485 and get an EAD by November 2024. Possibly, probably unlikely nowadays based on current processing times, because if you're filed your PERM just last month, you're looking at possibly not getting the approval until May 2024. And then you can immediately file the I-140 and the 485, assuming your priority date is still current at that time. But EAD processing times, a lot of times are getting closer to 8 months. And for that initial EAD. So it's very likely that your L-1B is going to expire before you get that EAD card based on processing times today. I think it's very likely that you're going to have to file that L-1B renewal. The good thing is you can wait until November 2024 and make the decision and file the L-1B renewal. And as long as it's filed before the current L-1 expires, you get 240 days of work authorization, even while the L-1B is pending. So that can allow you to keep working. You don't have to get the L-1 approval before November 2024. As long as it's filed before your L-1B expires, you can keep working while you wait for the new EAD to come in.
Afreen Sheikh has this question. 485 interview is scheduled, and the I-485J supplement, he saw the net income of the company is around $20,000. Will it be any problem in getting the green card because the net income is only $20,000? I don't see that as a problem at all. We have seen some of the I-485Js, which has a minus figure in there too. We haven't seen that as a problem in getting the 485s approved. Definitely when there is a minus figures for a small company, there may be some questions coming out, but since your case is actually, it's not a minus, it's you have a $20,000 plus, definitely I don't see that as a problem at all in getting the 485 approved.
SB says the L1 is maxing out in April 2025, and the H1B has not been picked in the last 5 times. Did receive the EAD and the AP based on an EB1 recently. That EB1 I-140 is approved, and he wants to know, can I safely work and stay in the U.S. beyond April 2025? Yeah, so once the I-140 is approved and you've got your 485 pending, for the typical run-of-the-mill employment-based applicant, it is relatively safe to forego your non-immigrant status and just rely on the pending 485, the EAD, and the AP. There are not a whole lot of things that go wrong in a 485 that would cause a denial, assuming it's your basic 485 application. Now, if you have past immigration violations, if you have criminal history, things like that, it may be safer for you to continue your L1, and that could be a problem for you to extend beyond the, I'm assuming this is L1A, so the 7-year limit. But if you're in the situation where your L1 time is running out, your 485 is still pending, you have the EAD AP, you can legally, lawfully remain in the country based on the pending 485, work based on your valid EAD, and travel using your AP and not have the L1 going forward from that time.
Question from Kiran. Does Reddy Neumann PC file adjustment of status for the spouse, even though the main application was filed by the employer's lawyer? Yes, we do file the 485 application, even if the main application has been filed by somebody else. Can this question from BNKB, can we file EAD and AP renewals after it is expired? Yes, you can file the EAD and AP renewal after it is expired. But the rule is that you cannot work based on the extension, based on the EAD pending. If the EAD extension has been filed before the EAD expires, you can work up to 540 days, even though your EAD expired, based on the receipt notice of the 765 application though. But when it comes to your filing it after it expires, you cannot work based on the receipt notice, but you can file the application even after it's been expired.
KGS says, I filed the H-1B and H-4 together. The H-1B was in premium, so the H-1's approved, but the H-4 has been pending for more than 3 months. So under current policy, that should not be happening. So I'm assuming the H-1B and the H-4 were filed in premium together, and this was after the date that USCIS re-implemented bundling the applications together, which means they should have approved both together. And so if they have not issued an RFE or something like that on the H-4, the employer or the employer's attorney should be reaching out to the premium processing unit, asking them what's going on with the H-4 and pointing out that policy that requires USCIS to adjudicate them together. If the employer or the employer's attorney is not willing to do that, that's where it becomes more difficult, because you as the employee or your spouse as the H-4 cannot contact the premium processing unit. So you're just having to have your wife contact USCIS via the customer service. May want to consider litigation for the delay in the H-4.
What will happen to the spouse green card application if the primary applications decide to divorce and leave the country? If the 485 is still pending, though, if divorce happen, then you will not get the green card. You're not supposed to get the green card, though. If your green card is already approved, especially in the employment-based green card, though, you get to keep the green card. Absolutely not a problem. But if it's pending and the spouse is going to give a divorce or going to leave the country, it's better that you consult a lawyer to have an alternative plans if that happens, if the divorce or leave the country, though. If the husband is
AJ says, my H-1B got approved, but the date of birth is incorrect on my I-797 and I-94. How can I correct it? Well, because it's an H-1B, only your employer or the employer's attorney can correct it. And number one, they need to check, was it their mistake or was it a USCIS error? If it was wrong on the I-129 petition, the only way to fix it is to file an I-129 amendment asking to correct the date of birth. And that's something only the company can do. If it was correct on the I-129, then the employer or the employer's attorney can contact USCIS to request correction of the typographic error. They can do it online through the My USCIS, through the e-request tools, and cross your fingers and hope it works, because that system is kind of a mess right now. I did the same thing for an error in a company's name on the approval notice. And after waiting for 30 days, USCIS came back and told me that I'm not the attorney on that I-129, even though my name is on the approval notice. So we tried calling, well, first we tried another service request online and got an error message saying you can't put one in because the previous one is still open, even though obviously it's not, because we got the response. So called customer service, got all the way through. After 10 minutes of talking to this officer, giving him all the information, at the very end, he says, I'm sorry, I can't put in a service request. You have to wait 15 days. All of that just because the company name said Inc. instead of LLC. So best of luck to you. Hopefully your employer or their attorney has better luck. If it was premium processing, they can reach out to the premium processing unit by email and hopefully get a better response than I got.
Question with regards to I have an H-1B, I-140 approved. Can I move to F-1 visa and then come back to H-1 at a later date? We have not seen any problems about that, moving to F-1s, even though you have an I-140 approval, and moving back to H-1Bs, we haven't seen any problem in that. Yeah, there is a chance you may face an RFE. There's a chance you may see a denial of the F-1 because you have an I-140 approval. But have you seen any of the denials, Emily, when the I-140 is approved?
Denial of F1 or B2? Sorry, I wasn't listening.
F1.
I have not.
In B2 also, have you seen any in the
Yep.
B2? Have you seen any B2 denials recently with all the
No.
people moving? No, okay. Yeah, I haven't seen it either. So yeah, we haven't seen that as a problem at all. Thank you for all the comments on my.
Sorry, go ahead. I was going to say, BNK asked, can we file the EAD and AP renewals after they're already expired? Yes, you can, as long as your 485 remains pending. Just be aware for the EAD, if you file the renewal after it expires, you don't get the automatic EAD extension for 180 days or 540 days. So you can't work if you don't have that valid EAD, assuming you don't have a non-immigrant status that allows you to work.
Hey, thanks for all the comments about my Kathmandu visit. I'm on the way to Tibet for Kailash, so I will not be available for next week. We'll be doing a trekking, very hard trekking at 18,000 feet. I did visit Pashupatinath, as Mr. Nepal has suggested. Anything else, Emily, before we close?
Nope, I think we're out of time for today. Thanks everyone for joining us. Please send your letters, write the letters, share your story. I shared a video on Twitter earlier today of a 14-year-old girl who so eloquently explained what the problem is with our immigration system being the dependent of legal immigrants.
Yeah.
That's how you advocate. That's what you need to be doing. Tweeting is not going to do it. You've got to do the work, send the letters, share your story, get out there and advocate. Don't sit behind a computer and do it.
Especially teenager, the TED Talk, that was very good. I was very impressed with that girl, Emily. Thank you very much for tuning. We'll see you next week.